Hello, welcome to our MicroSeminar on credit damage. My name is Jason Castillo. I'm the Director of Legal Education with Attorney Credits. Let's jump right into it, shall we? So, credit damage. You might be asking yourself at home, what is credit damage? Well, I've had the privilege of working with one of the foremost credit experts in the country, George Finder, an independent credit evaluator, who we've done a number of courses together and have written a number of materials with George as well. So what I'm going to do is I'm just going to jump right into it and give you a definition. I'm going to just tell you about it, give you a few cases. And this is something that can definitely help you out depending upon whatever area of law you may practice in, because it's not a cause of action, but rather a theory of liability and a type of damage. This can be added on to a number of different claims from bankruptcy to personal injury and can significantly enhance the recovery in your cases. So credit damage. This is a special damage evinced by loss of credit capacity, loss of credit expectancy, or increased out-of-pocket expenses due to third-party actions that cause negative credit information to appear on a client's credit report. And now, so some of the finer points here, because again, I often get, what is credit damage? Well, this is kind of a new type of damage, a damage for the digital millennium. Due to the increased dependence on credit reporting, this is a new form of damage, and it's a damage to one's financial reputation. Now, you would probably think of it like a defamation claim, right? Where defamation, you're compensated for damage to your personal reputation. If I go around telling everybody in town that you've got a venereal disease, a loathsome venereal disease, then you're going to suffer. You're going to be compensated because of it if that's not true, and I'm going around town spreading these rumors. I've damaged your personal reputation, which in turn is going to significantly affect the amount of opportunities available to you. Well, in the same respect where, libel and slander, these are personal damage and personal defamation, credit damage is damage to your financial reputation. And that's what we're getting at here. It all is about the credit report. And now your credit report is one 3-digit little number that's got a significant impact on your cost of borrowing and the effect and the ability of you to enjoy your life and your credit. So monitoring that credit report is incredibly important. And I mean, the drastic cost of borrowing increase, say when you lose 200 points from 800 to a 600, that can cost your client, $30,000, $40,000 on a $100,000 loan. So these are major damages that can be done. So let me run through a few cause of actions for you so you can kind of get your bearings on where this is involved. So these are some cases that I worked with on one of these different experts. So now this case was an identity theft or fraud case. Plaintiff had discovered that defendant stole approximately $40,000 of plaintiff's credit capacity and caused negative credit remarks to appear on plaintiff's credit reports. A settlement offer of restitution for only $40,000. Case ended up selling for $170,000. This is a breach of contract claim. It was a plaintiff's $300,000 demand. They sought $200,000 in compensation for credit damage when defendant failed to sell plaintiff's resident while in foreclosure. The settlement there was $22,000. We've got a violation of privacy. This was a major claim, improper access to the credit report, and these are hard or soft pulls, which are unauthorized by your client. So here the plaintiff discovered the defendant was accessing his credit report repeatedly without permission. It's 12 times. The defendant continued to do so even after agreeing to stop. Imagine that. Court found in favor of the plaintiff in the amount of $930,000, so almost $1 million for 12 impermissible pulls of a credit report. Here's another one, collection agency abuse, Fair Debt Collection Practices Act violations. Plaintiff suffered reputation damage, loss of credit capacity, and increased out-of-pocket expenses of $270,000 plus. Verdict in favor of the plaintiff in the amount of $890,000. And then here we have a collection abuse fraud, Fair Debt Collection Practices Act violation. Again, plaintiff suffers reputation damage, loss of credit capacity, and increased out-of-pocket expenses, and that's $50,000 plus. Verdict in favor of plaintiff, close to $300,000. So I'll get into a few cases in a little more detail later. Let's jump back into things and where are the sources of law? Where is this credit damage coming from? So basically, you've got two sources of law. You've got state and federal, just about everything else. Depending upon what state you're in, it's treated somewhat differently. Under the federal regime, you have the Fair Credit Reporting Act, which is a powerful weapon in your arsenal. So as far as common law goes, state statute. Now in a state like California, we have Civil Code 3333, which is basically the measure of damages for tort. So bear with me for a minute while I read the statute. California Civil Code section 3333 reads, for the breach of an obligation not arising from contract, i.e. tort, the measure of damages, except where otherwise expressly provided by this code, is the amount which will compensate for all the detriment proximately caused thereby, whether or not it could have been anticipated. And that's the key language there. If you injure somebody in tort, you're responsible for all the damage to make that person whole again. And now here we have a case for case law from California from 1912, Seminoff versus Goodman, where the court recognized the value of good credit even where the victim had no future plans to take out a loan or use the credit. So indeed, credit damage has been recognized for almost 100 years in a state like California. And now under the statutory regime, you have the FCRA, the Fair Credit Reporting Act. Now the FCRA was enacted to promote accuracy, fairness, and privacy of information in the files of every consumer reporting agency. These are called CRAs. These CRAs, or credit reporting agencies, the FCRA puts special duties on them and information furnishers to accurately report a person's credit history and transactions. So you may have noticed in that last sentence I mentioned two different parties there, CRAs, credit reporting agencies, and information furnishers. These are mainly creditors. So the CRAs, credit reporting agencies, you basically have the big three: Experian, TransUnion, Equifax. And now credit information furnishers, you've got millions of them. Home Depot would be one, Kmart, any store, any retailer that does credit transactions, they generally report back to these credit reporting agencies. So for example, when a credit reporting agency receives notice from a consumer that he or she is disputing a credit entry involving, say, for example, a Kmart charge, then the CRA, the credit reporting agency, is supposed to send all the information back to Kmart. Kmart, as a subscribing creditor or information furnisher, then has four duties. One, to conduct an investigation with respect to the disputed information. Two, to review all relevant information provided by the CRA. Three, to report the results of its investigation to the CRA. And four, if the investigation finds that the information is incomplete or inaccurate, the information furnisher has a duty to report those results to all of the CRAs to which the furnisher furnished the information, if indeed that the information is inaccurate or incomplete. And while the statute also puts special duties on the CRAs, it's almost impossible to sue the credit reporting agencies because they are so well insulated.